Again, Judge.
Thank you.
Thank you, Ted. Next, we have two nominees to be senior judges. First is the Honorable Jonathan J. Kaplan of South Windsor. Good afternoon, Your Honor. Please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
It's customary to open with an opening statement if you choose to.
Thank you. My name is Jonathan Kaplan, and I've been a judge of the Superior Court for 24 and a half years. My first appointment was November of 1985, which was an interim appointment, and my first 8-year appointment was 1986, which puts me on this cycle with the others. I want to thank Governor Rell for renominating me for another 8-year term. And I want to thank the committee for your patience. It has been a long day for all of you and all of us, and I thank you for your patience and waiting to hear from everybody. During my 24 and a half years on the bench, I've served in almost every capacity throughout the system. Civil, courtside civil jury, criminal Part B, criminal Part A, housing court, habeas corpus, which is an area that very few judges get a chance to work in. I've been a presiding judge in several different assignments, including GA 13 up in Enfield, and I've been administrative judge for 2 separate 5-year terms. I believe I'm the only judge in the state who's actually served 2 5-year terms, separated by my time in Enfield. And December of 08, I elected senior status, and I've been working as a senior judge since that time. And as a senior judge, I've worked exclusively on mediation of civil cases. And currently, I'm mediating cases out of the Rockville district, but I take the Town Judicial District, which is Rockville. But I take cases from courts around the state, and the settlement rate is running somewhere between 80 and 85%, which is pretty good percentage to alleviate the civil trial dockets. In fact, sometimes the trial judges are upset because they run out of work because the cases get settled. I'd be happy to answer any questions committee members may have.
Thank you, Judge. And both yourself and Judge Cicchino are in this category called senior judges, and I think there are people watching on CTN, they may not know what that actually means. And correct me if I'm wrong, but we have a mandatory retirement age of 70 for Superior Court judges, but prior to the time you turn 70, you can elect to become a senior judge. We work on a per diem basis.
Correct. And
you're paid a rate of pay for that alone.
That's correct.
Is that essentially it? And you elected to take that status in December of 08?
I elected December of 08. I was actually eligible in December of 05, but I stayed on as administrative judge for another year and a half, and then December of 08, or 2.5 years, December 08, I took my position as senior status, which allows me to work part-time or full-time if I want, and the days that I work, I would earn a per diem in addition to the pension, which I am already drawing. The class that we went on together, which included Senior Judge Cicchino, but others who were here today, Judge Damiani, Judge Norco, myself, Judge Koletsky, we were all in the same class going on together, and we're at all different stages at this point.
Got it. Judge, you mentioned that you've done a fair amount of work in the civil court in addition to the criminal court, and one question that's come up recently is with the fiscal crisis that we're dealing with at the moment, there's been a number of cuts. One of the cuts is in funding to legal aid that helps provide attorneys for indigent persons in many civil cases, including divorce cases and restraining orders, that type of thing. Have you noticed an impact? Are there fewer legal aid attorneys available? Are there more pro se or self-representing clients coming before the court now because of that?
I think the answer is yes. The problem with one of the problems with legal aid is that it was greatly funded by the IALTA, the interest on lawyers' trust funds accounts, and that's way down because interest rates are so low. So even if the same amount of money is on deposit, the interest rate is probably 1/5 of what it was 5 years ago, and therefore there's a lot less money available for legal aid and other organizations that received IALTA funding. So that's part of the problem. For many years, though, I've seen a reduction in legal aid lawyers available in civil cases, housing cases, family cases, and other civil cases. It's picked up a little bit by lawyers who do pro bono work. We have a lot of lawyers in the state of Connecticut who do pro bono work.
Pro bono meaning without charge. Yes.
Without charge. And they take some very difficult cases and they handle them without charge, which is quite good to see. But, but you still see, I think, a lot more self-represented people today than you did, say, 5 years, 10 years ago, and I'm sure that's a reflection of the economy.
And some people have made the point, I'm just curious if you share this opinion, that people coming into court without a lawyer representing themselves, it takes a lot more of the court's time, does it, to have to explain things to people, that type of thing? Is that the case?
And also you have more interruptions because they may have to file certain documents, they don't understand that, so you reach a point in the hearing where you're asking for these documents, they don't have them, you have to recess, give them an opportunity to get documents. Sometimes you have to continue the case, so it could probably take twice as long to try a case just because of the procedural difficulties. One of the things that has made a tremendous difference in the system, I've seen a lot of great improvements in the system through the years, but one is the court service centers. And I wish there was more money to have more court service centers. They take pressure off of the clerk's offices. They take pressure off of the judges in the courts, and they present a wonderful benefit to self-represented people. The court service centers, since they started running in every district where they exist, I think have been a great success. Most districts, when I was an administrative judge, I wanted a second court service center. There was no money to do it, but I think that's a wonderful thing that we've done, and if we do finally get some decent funding, as Senator Kissel said, maybe around the corner or over the clouds, another couple of years there'll be some more money. One of the first priorities might be adding court service centers. They really are a great benefit.
And these centers are sort of like information booths, but help you understand how to fill out documents, which documents?
Forms. The people who run the court service centers, I believe, in all districts are notaries. If not, they would have access to a notary right nearby so they can notarize documents. They actually have office setups. It's not legal services as such, but they are definitely providing a benefit and a roadmap to people to get through the system.
They're not giving out legal advice. They're just helping.
No, they're helping them fill out documents, which room to go to.
Well, thank you very much, Your Honor. Are there other questions? Senator Kissel?
Thank you very much, Mr. Chairman. It sounds like similar concept to the court greeter initiative that Judge Norco spoke about. Can't believe you've been on the bench as long as you have, pretty much since I passed the bar exam, so we've been at this for a while now. I know that you didn't discuss this in your opening statement, and to be honest, I've had these individuals write to me over the years. It seems like this issue came up the last time you were before us, but it couldn't have been. So you don't have to if you don't want to, but there's two individuals that have contacted this committee regarding concerns that they have with your renomination, and I just want to offer you the opportunity, if you want to say anything about these matters, to give you that opportunity to do so now. And the first one is regarding anything you may recall regarding Stephen Erickson.
I'd be happy to take the opportunity to try to respond. I can't control what people say. I can't control what people put on the Internet or what they say when they contact the committee. I received a document that presumably was submitted to the committee members. I don't know, but it was a 4-page document involving Mr. Erickson, and I read through it, and it is filled with half-truths, untruths, but I can't go through it item by item arguing about it because it's simply going to be my word against his word. I presume he believes what he's saying, but he makes accusations that just are simply not true. How else I could respond to it, I don't know, but if you have any specific questions, I'd be happy to try to answer them, but it's very difficult. You can't prove a negative.
Being in the world of politics, I understand that, having gone through campaigns, it's very difficult. But clearly what you're stating here is that there's no merit to those allegations.
That's correct. Just pulling one out, because it's an easy example to talk about. He claims that I failed to recuse myself in presiding in his criminal jury trial. No motion was ever filed, to the best of my knowledge, by him or by his lawyer asking me to recuse myself. He claims I should have recused myself because sometime prior to that criminal trial, and I don't know if it was months or years, he supposedly sent a letter to me complaining about something I did. I don't have a recollection of ever receiving that letter. He filed a complaint against me, which was dismissed. And one of the things I believe in that complaint, he stated that the letter that he supposedly sent to me before this criminal trial regarding a housing case was anonymous. So how could I then know if 6 months or a year later, 2 years later, that this is somebody who complained about me if it was an anonymous complaint? And as I said, he had a lawyer at his criminal trial, and the lawyer never asked me to recuse myself. Had he filed a motion, I would have dealt with the facts on the record, but there's no record because it was never raised.
Thank you very much, Your Honor. And the other individual that's contacted us on a number of occasions regarding various members of the judicial branch, whom I believe may be in the room today, but regarding Christopher Kennedy, if you have any recollection of any allegations made by that individual.
By the volume of comments that you've received through the years and things that I've seen on the Internet and elsewhere, you would think that I've had contact with Mr. Kennedy continuously for the last 10 years. I had contact with him for about 6 months. I handled a restraining order that some other judge had signed ex parte. I handled the hearing to see whether or not it should be dissolved, modified, or continued. He represented himself. I believe that his ex-wife was represented in that hearing, but I can't recall. I think so. And I gave him all the latitude in the world to make his case. And at the end of the hearing, I decided, one, that I relaxed the restraining order with respect to the visitation of his 2 daughters, because there were no allegations of violence toward them. And I continued the restraining order with respect to visitation with his son, because there was a finding that there was violence toward him. Several weeks, I believe, maybe a month or so later, he went to the court in Hartford and took out an application for a restraining order. And the hearing, by the way, that I talked about was in Rockville. He went to Hartford and he took out a restraining order, applied for a restraining order, failed to disclose the Rockville case, which is required. And there's a box indicating whether or not there has been anybody in the case has been a witness in a case within the last 6 months, I think. And he checked no. And the hearing obviously had taken place 3 or 4 weeks earlier. As a result of that, he got a ex parte order giving him sole custody of his 3 children. I got a call from a state trooper who was called by a principal of a school saying, there's 2 orders here, they're in conflict with each other, what's going on? That was the first I knew that he had secured this other order. I quickly did a little investigation to find out, and I determined that a Hartford family judge had signed this order, but again had no knowledge of the other pending case. That judge rescinded that order, and I signed an ex parte order that returned the custody back to the mother. Because he had falsified information in that application for his restraining order and custody order, I reported that to the State's Attorney's Office in Hartford, and ultimately he was arrested for perjury. Those charges, I believe, were ultimately disposed of through an application for accelerated rehabilitation. That is the long and the short of my contact with Mr. Kennedy, but through the years, he keeps repeating the same allegations over and over. Therefore, it seems like it's been continuous contact. It just has not. And by the way, he did file a judicial review complaint against me, which was dismissed because of lapse of time.
Thank you very much, Your Honor. And I think it's helpful to hear your side of the story. When I looked at the additional information you provided, and it indicated that the matter regarding Mr. Erickson was from 2003, and the matter regarding Mr. Kennedy was 2005, I too was surprised, because I feel like we've been sort of, at least members of this committee have been receiving information about this for many, many years. And to note that in one instance, it was 7 years ago, and in another instance, it was 5 years ago. It just seems like I agree with you that it seems like it had been over a longer period of time. I know that probably wasn't fun for you. I appreciate that fact.
I don't think the hearings are intended to be fun, but...
No, but I also think it's important for the public to know that there may be areas that are, problematic, and that everybody has due process rights to come speak to this committee. We want to hear all sides of the story. Some of them are easier to sort of parse out than others. But I've had knowledge of your experience in the courts from people that have practiced before you, but at the same time, I think it's important that we look into everything and take everything as objectively as humanly possible. And so you've answered my questions, and I appreciate your candor this afternoon in doing that, Your Honor.
Thank you, Senator.
Thank you very much, Mr. Chairman.
Further questions? Yes. Representative Gonzalez?
Good afternoon, Judge Kaplan.
Good afternoon or good evening, I'm not sure which.
Judge, I think that you're famous. If you go to Google, your name will come up, Judge Kaplan. And I think it's a lot of questions. I think it's a lot of concern because it's a lot of allegations against you. And some of those allegations are that you have told the defendant before you finish the case, you're guilty and you're going to prison. And they said that, people are scared at you at Rockville court. And also allegations are that you place papers in legal files at the court to influence the outcome of cases, different cases, when for some reason you don't like the defendant. There's so many allegations against you, Judge, that I believe that some members, they were concerned. And in the beginning, I thought that it's nothing against big guys, but I thought he was a big, judge. And I when I saw you today, I said, something's wrong. But I would like for you to explain a little bit about those complaints. I think that it's me asking questions, knowing that, allegations saying that if any person get in front of you and ask questions that you don't like, or any attorney that don't agree with you, you go after that attorney, you call some defendant's job, you make them lose the job, you go after these attorneys, you put them in jail. God, there are so many complaints against you, Judge. I would like for you to explain what's going on out there.
Thank you for asking the question, which gives me the opportunity to explain. The allegations that you're talking about, once again, come from two people. And they have made these statements over and over again to the point where people sometimes think they may be true when they're not. There are allegations that one of them that I told his lawyer to stop representing him That's just simply not true. I never said that. I never would. It just didn't happen. There was one allegation one of these people made was that I stuck my tongue out at him. Anybody who knows me just knows that's not how I operate. If anything, I tend to get quiet when I get angry. I don't yell at people. And I sometimes in court, either lawyers or sometimes the clerks will say to me, "Why do you let so-and-so go on for so long?" I let people talk very many times for 2 or 3 times what they should be allowed to talk, to give them the opportunity to get their point of view on the record. So when they said that I've cut them off and I didn't allow them to speak, or I didn't allow their lawyers to put on a case, it's just not true. I could tell you the one who claims that I told him something about he was guilty and he was going to go to jail before the trial was over. It's, I think, notable that his lawyer is not here making that same allegation, because the lawyer could not make that allegation in good faith. It's just not true. So, again, it's very difficult to prove a negative, but these allegations have been floated time and time again by 2 individuals. And I probably have come in contact with, in 25 years, I probably have come in contact with 15,000, 20,000 litigants. And when 2 individuals make these comments over and over again, you think it becomes true simply because they're saying it. It's just not true.
Judge, can you explain to me what is a habeas corpus?
Habeas corpus, under the statutory habeas corpus statute that we have in Connecticut, is a post-conviction filing asking for relief in a case after a conviction of a crime. There's other uses of habeas corpus. To bring a case into court from the probate court is one way of doing it, is filing a habeas corpus petition. But the kind of habeas corpus that I'm talking about in Town Judicial District are post-conviction cases. Most of them are claims, as one of the earlier, I think it was Judge Bishop said, of a claim of ineffective assistance of trial counsel. But one of the problems that develops through the years as our law develops in this area, that you now have ineffective assistance claims of appellate counsel, of habeas counsel, of the clerks. Some claim that the clerks have done something wrong with the case, a judge has done something wrong in a case. So it's developed into a much broader area than a single petition saying, my conviction is illegal because. And what they were talking about before with subsequent petitions being filed, I've had cases where there have been as many as 7 habeas corpus petitions filed by one individual, basically saying the same thing 7 times over, even though it was denied once. A year later, they file another one. 6 months later, they file another one. Another year, they file another one, basically making the same allegations.
And my question is because I received a couple of phone calls saying that inmates in Rockville, they've been treated real bad, that they apply for habeas corpus, and you keep denying every inmate that go to your court. That's one of the complaints out there.
It's very interesting because the habeas corpus docket in Town Judicial District, while I was administrative judge, went from about 350 cases to 1,700 or 1,800 cases because we took the entire state's habeas corpus cases and brought them to Rockville. So I oversaw the management of that docket, which had as high as about 1,800 cases. I think under Judge Solomon, who's the administrative judge now, I think the numbers are down to about 1,500 cases, maybe even less. So I authorized the filing of many of those petitions. When a habeas corpus petition is filed, it can be rejected or accepted. I rejected very few initially. Most of them were accepted. Sometimes they get dismissed later on for some procedural reason, or sometimes After a lawyer is appointed, the lawyer files a motion with the court to allow them to withdraw because the case is frivolous. And I've ruled on those motions. So I couldn't give you a percentage that are approved for filing versus not approved, but it would be a much higher percentage approved for filing than not approved for filing.
And that was my next question about numbers. I have here, this is a Connecticut trial court official decision, and this is about an inmate that he was acquitted. And even if he was acquitted, he was committed to 20 years in prison.
Is that Mr. Dickinson?
Yes, sir.
Thank you.
Okay, and then even if he was acquitted, he was committed. And now, after he finished his term, 20 years, now based on this, they want to extend his time in jail for 60 more months.
Not in jail, in a hospital.
In a hospital?
Yes.
Even though that I read the whole thing, and the doctor is saying here that he don't need no more medication, that he's not dangerous to him or anybody else. So why is that they want to extend 60 more months?
I ordered him released, ultimately.
You ordered release?
I ordered him released. I didn't do the original commitment, I don't think, on Mr. Dickinson. I can't remember, because that was 20-some-odd years ago.
Yes.
I handled the petition to extend the commitment, and the state wanted to extend the commitment, I believe 4 years, maybe 5 years, but I think it was 4, after his full 20 years had been served. And I held a hearing, and after hearing from the doctors, I determined that he should be released because there was no valid reason to continue to keep him in a hospital. I think the problem there is that his personality conflicted with the people who were treating him at the hospital. He didn't follow the rules the way they wanted him to follow the rules. Therefore, they didn't help reorient him into society. So when it came up for the end of his term to see if he should be released or extended, they said, well, he hasn't integrated into society, so he should be extended. After the hearing, I determined that was not correct, not accurate, and I released him. I think the extension, by agreement, by the way, he had a lawyer and agreed to an extension while he was being examined by a new psychiatrist, was about 14 months. But other than that, I terminated it.
Thank you, Judge.
Okay. Any other questions?
Are there further questions?
Thank you.
Senator Gomes?
Good evening, Judge Kaplan.
Good evening, Senator.
Some material was placed in our hand today, and it was quite extensive, and I read through it. If I found any credence in it, I would question you vehemently. I don't, in all fairness to you, I don't find any credence in it, and I want to go on record to say I apologize for even reading it.
Thank you.
And like I said, if I found any credence in the charges that were in this document, I would have no qualms at all about questioning you. And I think in fairness, I should put, on the other hand, I should declare that I don't think this sort of thing, the next time something comes up, it should be passed out. Thank you.
Representative Green next, then Representative Amon.
Thank you, Mr. Chair. Good evening, Your Honor. Just a couple of questions. I want to follow up on something about the habeas corpus. Can you tell me what is your opinion as to whether or not we should continue to have those in the state? Do you feel there's a misuse of them? What's your opinion?
Absolutely, we should continue to have a habeas corpus program. As Judge Bishop pointed out, it has been used to right some wrongs in the past. A case that he tried, a habeas corpus case, he found a petitioner who would be a defendant in a criminal case, as a petitioner in a habeas corpus case, was actually innocent, and he was released from prison after, I think, 15, 16 years. That proves that there are cases that require this sort of post-conviction look. The problem is there are a fair number of frivolous cases. there are a fair number of cases filed in multiples over a period of years. But I think we should work within the existing system to find some way to deal with the problem cases as opposed to throwing out the whole system, because habeas corpus is deeply rooted in American jurisprudence and in Connecticut by statute as well as the common law. So I think we should maybe improve what we have, but we should certainly not throw out the system.
Can you maybe give me an example of how you may feel something, one of those, the process might be deemed to be frivolous? I mean, is it because of the number? Is it because of the type? Is it because of the timeline? They do it every 6 months. I mean, what would make it frivolous?
Well, sometimes you have a case where a inmate files a habeas corpus petition, there's a hearing held, it's denied based on the facts presented at the hearing, goes up on appeal, it's affirmed on appeal, and then he files another one with basically the same allegations. I had one case where there were 7 petitions filed over about a 5-year period, making the exact same allegations each time, after hearings were held and concluded. Finally, one of the lawyers appointed to represent that petitioner filed a motion to be allowed to withdraw as counsel based upon the fact that the claims were frivolous. We have a statutory procedure for that, or practice book procedure, I stand corrected, for that. And the filing is called an Anders brief, A-N-D-E-R-S, based upon a California case that went to the U.S. Supreme Court. But that's a whole separate proceeding, and the presiding judge of habeas, or in Rockville, usually the administrative judge does it, and that's why, since I was administrative judge 10 years, I handled probably about 200 Anders files during that period of time. The judge reviews everything, the record, the files, all the documents, all the pleadings, makes a determination that the case is frivolous, allows the lawyer to withdraw, and then allows the petitioner to either proceed pro se or sometimes to appoint a new counsel, but it's pretty unusual to appoint new counsel.
In the situation that you described, that someone was able to get, it sounded like 2 different orders from 2 different judges, could that happen still in our system? Did we learn anything from that process?
We definitely learned from the process, and I presume it's still in effect, but shortly after that, we got some of the presiding family judges together and talked about when somebody comes in making an application for an ex parte order like that, that somebody in the clerk's office runs the file through the system to find out if there are any other pending cases. Had that been done in that case, that would have been picked up instantly, and I think the result would have been very different.
Have you heard about any other cases where something like that happened after this situation?
I haven't, but I also haven't been sitting on family for several years now, therefore I would not necessarily be privy to that information.
Okay. Just 2 more questions. You had mentioned something, and it sounded like you were concerned about individuals coming in court and maybe trying to represent themselves. And I guess I have some concern with the court proceedings, especially when individuals who had no contact with courts, never been arrested, really never been in the system, first come into the system. And I think a lot of times you come in the system believing, sometimes what you see on TV and the Perry Mason and stuff is that, you're going to come in and there's going to be a sense of fairness, a sense of justice. And you go in and you almost treated like a criminal for the first time. So what happens is that I think a lot of people who regardless of guilt or innocent, they believe they're innocent. They come in and saying, well, once I go in and present my case, they'll see that I'm innocent. And it's not like that. And so I didn't know if you were saying that there's some other things we can do to help people understand the process, or were you recommending or suggesting that people should not represent themselves? And I'm trying to get at how can the court be better at trying to, in a sense, help those individuals who might be new to the court. I could go to the court system and look around and tell a family or individual who's there for the first time versus somebody who know the system. And I'm wondering, does the court do any of that to try to maybe assist some people, not regardless of guilt or innocence, but through the process. Should the courts
Yes.
have any of that responsibility
And
or no?
I think the court service centers do that to some extent, but not, they don't cross the line to give legal advice. They're not
Right.
lawyers. But they can help somebody out understanding the process and the system, programs that they could apply for, and that type of thing. Most of the time on criminal cases, a defendant is better off being represented by counsel than representing themselves. But some people can do a good job representing themselves. But most of the time, even if a lawyer is charged with a crime, the lawyer would probably be well advised to be represented by other counsel, because it's hard to be objective when it's your own case. And if a lawyer is arrested and charged with a crime and is represented by counsel, they can have confidential communications, and the counsel can convince them that you've got a problem here, you have a problem there, where they may not see it themselves. So certainly, non-lawyer pro se's would be better off most of the time having counsel if they qualify for it.
So you strongly suggest that everyone have counsel when they come to court?
It's a good idea. And our public defender system in Connecticut is outstanding. So if people qualify for public defender services, they'll be entitled to a lawyer and they'll get good representation.
It seems to me, I mean, the times I've gone to court, you get there early, you talk to the prosecutor, and pretty much what the prosecutor decides is kind of where it goes, but I won't get into that. And last question is that we have renominations up. I've been on this committee long enough to see a lot of renominations, and I've always tried to be able to gauge or try to figure out what might help me to distinguish should I support someone for renomination or not. Could you maybe give me one or two things that maybe as a committee member I should look for to decide how would I judge whether or not a judge should be renominated? What do you think I should look for?
I think judicial temperament is one that obviously comes to mind very quickly. I think you want people on the bench who are patient and listen to people. I think you want people, obviously, who have the intelligence and the legal ability to do the job. That's important. But judicial temperament goes a long way to making somebody a good judge. If they're patient and they listen to people, it really makes a big difference.
All right. Thank you.
Is there anything further? Representative Amon.
Yes, thank you. Judge, back in 1985, when you originally were appointed to the bench and you testified, you talked at length about the fact that you were looking forward to serving as a judge and being able to handle a multitude of different type of cases, and were going to be able to look at many different aspects of the law. Since 1985, we've had more and more specialized parts of the court, specialized dockets, et cetera. And I'm wondering, from your experience over the last year since 1985, do you think that trend towards more the judges specializing is a good trend or a bad trend for the state as a whole?
I think you need a mix. Some judges are generalists and they'll do lots of different things, and that's good. They're very versatile. Again, being an administrative judge for 10 years, it was very important to me to be able to ask a judge, could you go over and try a family case today? Could you try a habeas corpus case today? And to have versatile judges do that is really very good for an administrator. On the other hand, somebody, Judge Skolnick earlier today was talking about doing asbestos litigation. You could become very skilled at doing one type of litigation like that and do a very good job. And that might be the kind of area that needs, like complex lit, you need somebody who's willing to really sink their teeth into complex cases. So it's good to have a balance of some judges who do a lot of different things, and I came from the background, as you know, I believe, from private practice, so I had that general background, and the last 24 years I've done that. I've sat in just about every area, and I've done administrative appeals, tax appeals, things like that from time to time. So, I think the balance is good. Some judges a little more specialized, some judges a little more generalized.
As the judges become specialized in a particular area, do they start developing a bias, especially in civil cases, that because they've seen the same type of case on a regular basis?
Probably not. I think judges are skilled at not, if they see some biases bubbling up, they're skilled enough to deal with it. But I think what might happen is they may become attuned to certain aspects of a certain type of case. Judge Skolnick was talking about the summary judgment motions being filed by a lot of the defendants in asbestos cases. I'm sure after a while he knows which facts to look for in those motions to see whether or not he's going to grant them or deny them because of doing so many.
Thank you. The subject of judicial temperament has been brought up several times, and I just want to make a comment about Judge Kaplan. I was on the South Windsor Town Council, and I may have been mayor at the time that Northeast Utilities wanted to put in some electric power lines. They went past Town Hall. They went past a very historic church in town. And so you can imagine the emotional part of a lot of people in the case that you were handling. And I am delighted to say that while I heard an awful lot about that case, and I heard an awful lot about what the church's position was and Northeast Utilities, what I never got from anybody was anything other than the judge who was handling it was treating the case with knowledge and fairness. So I definitely think on that case that I had experience with hearing about, you definitely meet the judicial temperament that I'm looking for in a judge. So again, I thank you very much for your service over the many years.
Thank you. In that case, I put on the record the first day that the power lines run behind my house. And they all agreed to let me hear the case anyway, and I think they were pleased with the outcome.
Representative Hewitt?
Good evening, Your Honor.
Good evening.
I was reading over the complaints against you. I mean, you have some serious, this is book material, man. I mean, it takes a great amount of creativity to come up with some complaints like this. And I just got one question I want to ask you. Has there ever been a time that you ran into Mr. Kennedy outside of your chambers, in the hallway, the bathroom? I mean, I'm pretty sure you used the same. No, you probably have your own bathroom inside of those chambers. But was there ever a time when you ran into each other in the hallway or anything like that?
He makes claims that I have seen him in the hallway and made comments to him and times stared him down. It's just not true. I can't stop him from making those comments. He's got a First Amendment right to say whatever he wants to say, true or not. But I certainly have never, I may have passed him in the hallway. I walk through the hallway every day, and I pass from the clerk's office to the room I do my mediations in. I have to walk through a hallway or a lobby that most of the time has about 200 people in it. So I walk by people all the time. Some people whose cases I handled and they're not happy, and other people who are glad to see me and say hello. So I may nod, I may say hello, I may smile, but I certainly have never threatened anybody or stared anybody down. And I know those allegations have been made. It's just not true.
How about the parking spaces? Do you park in a different parking lot than the people that are going to court?
In one courthouse, yes. In one courthouse, no. And I read that comment, and I don't know where it's coming from. He has a vivid imagination. My thought is that it's easier to, you said this in the beginning, it's easier to write fiction than nonfiction.
And it's up to me whether I believe him or not, or whether I believe you. That has a lot to do with temperament also.
That's your job.
I mean, you are looking me dead in my eyes. I like that. But I just wanted to ask you those questions. Thank you very much.
Sure.
Anything further? If not, thank you very much, Your Honor. Next is the Honorable